Any more questions for him of the court before you go ahead with your plea today?
You said no.
Oh, no, I'm sorry. I didn't hear that. State will tend to the plea.
May I just ask a quick question? I had a chance to review the probable cause affidavit, the driving record, the charges of first offense. Was there something aggravating about this case that required the sober link that this is not in the court file?
Judge, there is an allegation of mistesting on sober link previously.
Okay.
And as part of this condition of release, and there's an allegation that this test has indicated he's filing a motion to vote on to a resolution. That's the reason why.
Okay.
There were no positive screens, there was a mistest. Now, Mr. Wood obviously takes position with that, and he has now cleared up the issue. And this was notification that we received a few weeks ago. He's now taking pictures of himself with his cell phone and being a little more detail oriented in logging his samples on the machine and verifying whether he takes the position that he's not the engineer stored in the unit that happens to have a service, they'll actually store and then upload
right.
And that was the discrepancy. So in light of dealing with a revocation hearing, it was all the case.
Okay. Why was he on sober link? I don't see it looks like he bonded prior to.
Judge, I wasn't part of that.
Judge, and I think I'm obligated, even though it's not it's charged as a first offense, I believe he had from the 1990s, early 1990s, some prior offenses from Illinois. So I think that's the basis for this.
I was seeing on the NDR, and I was not part of the first hearing.
All right, fair enough. All right, I did review the probable cause affidavit. I did find that there is a sufficient factual basis and venue. Ma'am, I need you to please turn your phone off. I do find that there's a sufficient factual basis and venue. I've considered the colloquy and find the plea to be freely, knowingly, and voluntarily entered. Therefore, I will accept the plea and impose sentence as follows. For the offense of DUI, adjudication of guilt, $220 in court costs, $1,000 fine. I'm sorry, 300. Hold on a second there. This thing on my screen covering up. All right, $388 in court costs, $1,000 fine, $50 cost of prosecution, 12-month license revocation, 12 months probation. Special conditions of probation are as follows. You must perform 50 hours of community service. You must attend and successfully complete DUI school appropriate phase, as well as the victim impact panel. You may not possess any alcoholic beverages. No entering bars, taverns, saloons, pubs, lounges, or package stores. No alcoholic beverages in your residence. You're subject to random urinalysis and breathalyzer at your own expense. You must have a SoberLink device installed for a period of 90 days starting today. 10-day vehicle immobilization. And you may petition the court for early termination upon successful completion of all conditions and having served at least 9 months. Was that all of the terms?
Yes.
All right. All right, good luck to you, sir. Do we have a fingerprint form for this gentleman?
Yes.
Okay, very good.
And Judge, if the court has no objection, is eligible for a hardship license Department of Housing and Review.
Ellen, is it too late to add that?
No, I can still add it.
All right, please put the court has no objection to the defendant in the hardship permit, if eligible. Yep. All right.
Yes, sir.
Good luck, sir. Thank you.
Sure.
Happy holidays, sir.
Have a good one. Thank you.
Take care.
Happy New Year.
You too.
Probably won't see you.
Well, I've got my my private counsel pretrial docket, so I take it back. I will see you. Never mind.
I'll see you soon.
All right. All right, Mr. Gorman.
Yes, Judge, can we first call Octavio Calderon, 20MM1944. This is defense's motion to lift the no contact order. We provided notice to the victim in this case, who is represented by Kristen Rogers. They are in court.
Who is present? Yep. Ms. Rogers, can you hear us okay?
Yes, Your Honor.
All right.
I was not aware. Ms. Rogers just informed me that her client does not speak English.
But they can come into the courtroom for this. Because this docket also has arraignments on it, I'm allowed to do it in person. And Ms. Rogers, I think that you're in the courthouse. I have
I
an
am.
interpreter present. Would you like to come in?
Yes, Your Honor. Are you in 3B?
I'm in 1B.
Oh, 1B. Okay. We'll be right in.
I'm a stone's throw away. I'll see you in a moment.
Okay.
So, Mr. Gorman, while we're waiting for her to come in with her client, did you want to address a different matter?
Yeah, Judge, I don't know how long it's going to take, but I know Miss Rogers has got to get to another hearing immediately in Judge Cohen, so she requested we address this as quick as possible because she's a little late.
All right, well, she's walking in now.
Yeah.
Thought she was.
I just saw her in the hall.
I know she was in the annex.
Yes.
Oh. Okay. All right. I apologize for the delay, Ms. Roger. We were having network connectivity issues. Yes, please. Yeah, we'll go ahead and address the case now. And apparently she does need the services of an interpreter, please. So I just would ask that everyone, do their best to remain, as everyone, to remain, at least some social distance. Thank you. All right. All right. Good morning, ma'am. And what is your name, please? Your name, please? You can't hear it because of the mask? Okay.
Capital L-I-U-Y-U-B-I. Last name capital A-P-U-R-E.
All right. And Ms. Roger, with your permission, I'd like to go ahead and swear her in at this time.
Yes, sir.
All right. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Put your hand down, please. All right. Mr. Gorman, go ahead. Once again, we're addressing
Yes, Judge.
David Calderon, 20 MM1944. Go ahead, sir.
That's correct, Judge. Mr. Calderon wished us to bring this motion. He wishes to resume contact with his wife. He provides support to the family. He wishes to reconcile with his wife. And that is the basis for bringing our motion here today. I believe there was no trespass and no contact order issued at first appearance. And I believe the victim will provide input as with regard to her position on it.
All right. This is,
Yes.
all right. Mrs. Roger, is that correct? Is your client's position that she is not objecting to the court lifting the no contact order?
That is correct.
All right.
Que usted no se opone, que se siga la orden de no contacto. No se opone. No. I am okay with it.
Okay. All right. And I assume, Ms. Roger, you've had the opportunity to have a detailed conversation with your client about her rights in this matter?
I have done, including sure anything were to happen, she could call me. She indicated her willingness to call 911 if anything were to happen. I just want to let her know I'm happy to help with all of those things. As far as all of that is concerned, she does understand and she knows what she's happening.
Okay.
Su abogado acaba de indicar que habló con usted, que le indicó todas las posibilidades que si algo vuelve a suceder, usted puede volver a llamar al 911 y usted insistió en estar de acuerdo en retirar la orden de no contacto.
All right. Mr. Stewart, does the state have an objection to the motion at this time?
Yes.
The state does object? All right. All right. Would you like to inquire of the victim?
Would I know? I don't have any questions for her.
All right, so but the state is still maintaining an objection?
Yes, I mean, I have an argument when the time's appropriate.
Time's appropriate. Go ahead, sir.
Okay, so Judge, I can't agree to this for two reasons. First, the court can see from the court file, the allegation is that the defendant was extremely intoxicated, punched the victim in the face, her head bounced off a wall, she lost consciousness, and she was bleeding from the head. So obviously, that's my first concern. My second concern is there was an arrest of the defendant in 2019, same victim. Case was dropped at the request of the victim in that case, but there was a prior incident, and the defendant also has prior alcohol-related offenses, 2 DUIs in his history. So I don't think it's appropriate. There's a pending prosecution. The state filed charges. I don't think, without any sort of showing that the defendant is in any sort of counseling, batters intervention, Alcoholics Anonymous, on SoberLink, something along those lines, I certainly don't feel comfortable agreeing to it.
Señora, el fiscal se opone a que la orden de protección sea retirada. Su esposo estaba terriblemente intoxicado. El día que esto sucedió, le dio un puño en la cara, estaba sangrando por la cabeza. No es la primera vez que eso sucede, desde el 19 también hubo un incidente en cual usted fue la víctima también. Tiene pendientes 2 casos de conducir bajo la influencia del alcohol. Esos motivos. Otra cosa es que tampoco ha demostrado que esté tomando las clases para controlar la ira, ni nada de eso. No tiene un brazalete telemático, así es que por tal motivo el fiscal no está de acuerdo.
Mr. Gorman?
Judge, right now, these are allegations. He's innocent until proven otherwise. And clearly the victim wants to, resume her relationship with her husband. I can't speak for the victim, but I can speak for our client. He wishes to resume his relationship with his wife. They are married. I understand the state's concerns, but right now our client is has a presumption of innocence, and we'd ask that they be allowed to resume contact with one another.
Mr. Stewart, was the prior incident alleged to be alcohol related as well?
Judge, you'd have to give me a second to.
Sure.
Judge, I don't, unless I'm missing it, I don't see that, but I think it is, now that you've directed us to this case, it's 192241 CF, and I think the allegations there, understanding that the charge wasn't filed because the victim requested the charge be dropped. But the allegations in that case were fairly serious as well. In that case, she alleged that the defendant slammed her up against the wall, placed his hand around her throat, then grabbed her by the back of the hair and threw her to the floor, hit her head on the bedroom table. She ended up acting as though she was unconscious, laying on the floor. in hopes that the defendant would stop beating her. He then kicks her in the stomach and pelvic region multiple times and then tells her if she contacts the cops, he'll kill her. I don't read anything about alcohol, but
Understand.
those allegations, granted, wasn't filed on, but concerning nonetheless.
La empujó contra la pared, le puso las manos en el cuello, la agarró con la parte de atrás del pelo, la obligó con un piso. Y parecía que usted estaba inconsciente. Y en esa ocasión también usted vino al tribunal y solicitó que le retiraran los cargos y la orden de protección. Eso fue el año pasado.
All right, Mr. Gorman, if you're asking me to modify the conditions of release to allow contact, I would do so, but I would add the condition of a sober link device and no alcohol provision.
Después debemos permitir que reanude su relación con la condición de que él haga algo en relación a la bebida y que también va a tener que usar un brazalete de tabaco.
This would allow the court to respect the victim's wishes, and I do feel comfortable, that she's been properly counseled by Mrs. Rogers.
Yo respeto el deseo de ustedes, pero ya sabe que él no va a poder tocar el licor
But we'll,
y va a tener que usar un brazalete de mano. Él prometió no tomar más. He promised that he is not going to drink.
well, he's going to promise me,
Pero no solo prometió,
and he's going to have to keep his promise to me, or he's going to be in trouble.
así es que si no cumple, él va a tener problemas. El poco él no estaba tomando. He wasn't drinking much, but on that day,
I understand.
entiendo. Nosotros no teníamos problemas. Ese día por eso no teníamos. Ese día no teníamos problemas. Ese día fue una diferencia con ayer. We were not having problems then, at least not with me, but that day he had a problem with his son-in-law.
I understand.
Entiendo.
All right, and ma'am, just to be clear, I need to hear this from you, ma'am. I need to hear this from you. Is it your wish? Is it your wish to have me lift a no contact order and allow this gentleman to have contact?
Es su deseo que yo renueva la orden de no contacto. Es su deseo. That is my wish.
And has anyone promised you anything or threatened you with anything to
Nadie
do
le ha
this?
prometido nada, ni la ha amenazado para que usted venga a hacer esa solicitud. No. No.
All right. All right, Mr. Gorman, the motion is granted with that caveat that I would add the condition in exchange for that removal of the no alcohol provision in the sober link device.
Recuerde que yo estoy concediendo la moción, pero él no va a poder tocar el licor y va a tener que estar usando un brazalete de mano. For how long will he have to wear the bracelet?
As long as the case is pending.
Mientras el tribunal lo determine,
Okay,
until the court decides, right?
until the case is resolved. Yep.
Thank you.
All right.
Judge, I'll get a proposed order over to the state and figure out logistics on getting that device installed. So, we'll need to talk to the client and then get all that. Mr. Stewart will be copied on the email of the proposed order.
Very good. All right.
Thank you.
Good luck, ma'am. All right.
Judge,
Yes, sir. Yes, sir. Go ahead.
we have one other matter. I believe it's the state's motion, 20 MS 298. We represent Cheryl Marie, who is the alleged victim in that case. I believe it's the state's motion.
All right. So this is State of Florida versus Kyle Horvath, Commander C 20 MS 298. Mr. Gorman said you represent the victim in this case.
That's correct.
All right. State, you were able to get, oh, hold on. There was an objection.
Yes, Judge, as I said, represent Ms. Marie. We filed a objection to the state's request to obtain her personal confidential medical records. We've attached an affidavit of Ms. Marie where she indicates as such, and so we're prepared to make arguments at the appropriate time.
All right. State, this is your motion. Go ahead.
You're muted, James.
Mr. Stewart.
Thanks, Mr. Gorman. Yes, this came in as an investigation from the sheriff's office that they wanted us to look at. The allegations in the attachment, I think, are pretty much say everything, Judge. The allegation is that the defendant, Mr. Gender C, had been physical with Miss Marie, and the allegation specifically was that he pushed her and she struck a concrete column just outside their front door, fell to the ground. He ended up calling an ambulance for her, and she was transported to the hospital, where the allegation from emergency room staff is that Miss Marie broke several ribs. So our motion is just to obtain her EMS and medical records from NCH. The burden here is relevance to an ongoing investigation. I think that certainly her records are relevant, and that's all we're asking for at this time.
All right, Mr. Gorman.
Yes, Judge. I've tried to do a bit of research on this issue, and I came up with nothing really as far as Florida case law, but the cases the state cites to are all related to the state's efforts to obtain medical records of a defendant. And I agree with the state, that is the standard, is relevance. However, I think that I did find a law review article that provides some arguments regarding today's hearing, but essentially our argument relates to our common law constitutional right to privacy under the Fourth Amendment, that individuals are free from unreasonable government intrusion into their person, home, property, papers, etc. And it's our argument here today that we've got an instance where our client, Miss Marie, did not want government involved in her life. They came through some efforts of, I believe, the medical staff is how it initially started. She's been contacted by law enforcement several times since this. She does not wish to speak to them or cooperate with them in any way or form. She believes that the records which are sought contain confidential medical records that indicate, as your honor's aware, as the state's aware, that as part of any hospital records, there's medical and mental health assessments, as well as substance abuse assessments, as well as prior medical conditions, which are all asked and documented in medical records of the nature which the state is seeking. Those are extremely confidential. To Miss Marie in particular, she does not wish them released. She does not wish to provide them to the government, and has hired us to make this objection on her behalf.
In a criminal case, though, it's the state of Florida itself that is the injured party, so to speak, right?
I understand, Judge.
So I mean, I'm only saying that because should it make any difference when the medical records sought are of the defendant or any other person? As far as the legal analysis to whether or not the state can obtain those records, does who the person is that they're trying to obtain the records from, should the analysis change depending on whether it's the defendant or any other person?
And I could tell the court, I don't see any case law that says victims have a special enumerated right under Florida law that says the law has changed. So my answer to that is, you're correct, Your Honor. That being said,
I'm not making a point. I'm honestly asking the question.
No. I agree with you, Judge. I believe that you're correct in that assumption, that I don't think, well, at least it hasn't been enumerated in Florida, that the law changes in any regard to whether it's a victim or a defendant. It is still the state has the right to investigate crimes as the victim themselves. That being said, we also have a conflicting argument, which is that under common law and under the Fourth Amendment, citizens have the right to be free of unreasonable government intrusion to their person. And then the crux of the issue is going to be, is this unreasonable or is it not? And our argument is that under Miss Marie's position, it is unreasonable. And I know the state makes an argument to the contrary, and they base that on their relevancy argument, which is the state of the law. But that's where we stand, Judge.
All right. All right. Over the victim's objection, the state's motion is granted. I do have a proposed order in front of the court right now. Mr. Gorman, do you have a chance to review this?
No, Judge, I have not, but assuming it's limited to the discharge and transport, we don't have an objection.
It specifically says it's regarding her treatment on November 23rd, 2020. It says it also hereby authorizes the state to discuss and communicate with all medical professionals contained in said records. That's the meat of the order. Okay.
Yeah, Judge, I would object to that just because, as I said, if they want to find out that her ribs are potentially broken, that's easy enough to find out from the medical records. But to talk about potentially her mental health issues or potentially substance abuse issues or perhaps potentially prior confidential medical conditions that are completely unrelated to the incident in question here, but are contained within all medical records from a hospital, we believe that is overbroad. Perhaps the state can tailor it to limit it to treatment regarding to the injury, any alleged injuries that occurred on that date, something to that effect.
Well, I think the last sentence refers back to the prior sentence that says that they're allowed to speak to medical professionals containing said records, meaning the records from the treatment on November 23rd, 2020.
And my problem with that is, Judge,
I understand there's information contained in those records that that may go beyond what occurred in this incident, but I don't see how you can ask a hospital to determine what is and is not appropriately responsive to the state's subpoena when they're asking for treatment of this issue. And so it's not just the injury necessarily that may be relevant, right? Impairment of a victim is certainly relevant. If you were representing the defendant, you would want to know if the victim was impaired. It would affect their ability to recall events, right? And the state would have an interest in determining that as well. And so, given that, at this point, I'm not aware of any authority that says that victims are treated differently than defendants and any other person under these circumstances. When the state is seeking an investigatory subpoena, the standard is relevance, and it's for the records of the treatment that occurred as related to the alleged battery. And so I understand your objection, sir, but the state's motion is granted.
Okay, Judge.
All right.
Have a good day.
You too, sir. Take care.
Take care.
All right. I've got a couple of folks in the courtroom I'd like to address, and then I'll address everybody else that's online.
That's Barboza here to law.
All right, Mr. Barboza is here. And for everyone who's joining us a little bit later, I apologize, I'm running behind. We had some technical difficulty issues. We didn't get started until about 9:30, so I appreciate everyone's patience. Good morning, Mr. Barboza. How are you?
Good, how are you?
Doing well. And Ms. Hall, you represent this gentleman. This is 19MM731. Where are we with this case?
Yes, Your Honor, all he had left was in the Constitution, and he brought in his final $100 payment and his money order that he just went off.
All right, Mr. Cruz?
We're showing that he owes, we sent one back to him, Your Honor. He had made it out incorrectly, and that amount was $140, and at that time he had a balance of $100.
And that was just paid this morning?
This is from 12/16.
I know, but Mr. Barboza has a receipt in his hand. Was that shown to Mr. Cruz?
It's the money order.
All right, was it shown to Mr. Cruz?
Sorry?
He's probation. He will confirm for me.
before we send it back. If you guys are mailing that's blank, that's what we want to see.
Okay. So are we
You
good?
filled out the pay the order of restitution balance, which we couldn't fill.
Okay.
So you're gonna need to take that to the, okay?
Can we do that now and then come back? All right, why don't you go take care of that, take it over to probation office, tell them Mr. Cruz sent you over here, come on back, all right?
Just gonna give you people to show that it's paid for. Okay?
All right. And then the other gentleman in the jacket?
His name is Jeffrey D. Pitchoff, 19 MM 2350.
Come on up, sir. This is 19MM 2350. Good morning, sir. And, sir.
Yes, sir. This time I'm just gonna request a continuance.
All right. State any objection to the defense's request for a continuance?
If I could have a minute, Judge.
Sure.
So I won't object, though. I would add that it's an old case. So perhaps next time we're on a pretrial docket and the court has an available trial cycle, we could set it.
Okay. Where are we now? How old is this case?
It's a little over a year.
Yeah. All right. All right. At this point, we can go ahead and continue it, but you know, we're probably gonna have to start heading towards a trial posture soon. Okay.
Yes, sir.
All right. Let me get my calendar here. My next pretrial docket. And so you're gonna need to talk to your attorney about either, you know, a resolution by way of a plea or your options for trial, okay? All right. It will be January 25th at 10 o'clock. All right. All right, we'll see you then, sir. Thank you. All right. Yes, ma'am.
I'm supposed to be in court with the county morning at 10 a.m.
Go ahead. I've got some folks on Zoom I can address. You want to go ahead and address Judge Brown's court first?
Well, I have pleas and I have a hearing with the state, the state promotion.
Oh, all right. So you want to address your cases now? Okay. Let's go ahead and do that real quick.
I got Jessica Adams, 20 MM 1788.
Okay. State no objection.
No objection.
January 25th at 10 o'clock.
Jarvis Rainey, 20 MM 276, also going to be asking for continuance of this one.
State no objection.
No objection.
January 25th at 10 o'clock.
First Rodriguez, 20 MM 1080, would like to be put onto the trial.
All right. There's a request for trial state. I'm back up the week of the 4th. So I'm setting cases for status, purely status, on January 4th at 9 o'clock for a remote hearing just to see where we are and whether or not we can have trials that week. Would you be ready to do that?
Yes, with the idea that the trial would begin on the 5th?
Yes,
What
sir.
day? Okay,
Yes, sir.
so we'll issue subpoenas for the 5th and it'll be set for status on the 4th.
Yes, sir. All right.
Okay.
All right. January 4th, 9 o'clock for status.
Next is King Walters, 20 MM 1436.
Okay. All right. Stay have no objection to a continuance.
No objection.
All right. January 25th at 10 o'clock.
And then Shamar Solomon, 20 MM 1818. Also.
All right. January 25th. I'm sorry. State no objection.
No objection.
January 25th, 10 o'clock.
And finally, Mr. Oakley.
All right. Mr. Robo's back. So did you get your receipt?
Yes.
All right. Please show it to Mr. Cruz. And state, what was the resolution if restitution is completely paid?
Can I confirm with Mr. Cruz that this individual has paid off all costs, including restitution and completed batter's intervention?
Mr. Barbosa? Is he done with everything? Yeah.
That's the one you told me. They are, sorry. He has completed batter's intervention. Looks like you have $622 left on the fine, Cameron.
All right.
The only outstanding condition over there.
All right. So there's outstanding fines. Where does that leave us?
Is there, a revised offer from, is there another offer from the state now that you gave it?
All right. So everything's taken care of except for his fines, Mr. Stewart. What's your position, sir?
Well, Judge, I just asked we move it to the 25th and see if he's paid off the fines by then.
Excuse me.
Yes, sir.
Last month, we talked about that, explained that I have some obligations that we're trying to take care of in Michigan. And that I was wanting to move on with that because we notified that it violated their.
All right. So you just want to be done with us today?
Well, Judge, I guess in the alternative, I would offer to revoke probation, resentence him to time served.
Okay. Time served. So basically, sir, your probation will be done. You still, the money is still owed. We go to collection, but you would, you're done with the VOP with us.
Yeah, thank you.
Do you want to accept that?
Yes.
All right. Then please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Ms. Hall, we're going to need a VOP admission form. But I'm going to go ahead and allow Mr. Stewart to inquire real quick, and we can go over the form with you in just a moment.
So at this point, Judge, we will dismiss the condition 12 and the two condition 12, since those have been belatedly completed.
Okay.
Mr. Barbosa, can you state your name and your date of birth?
Max Barbosa, 2/16/1977.
You're placed on probation for one count of battery. Do you understand the maximum penalty for that was a year in jail?
Yes.
And you're alleged to have violated your probation with condition 10, failing to pay fines and court costs. Do you wish to admit that violation?
Yes.
Have you read, you're going to read a waiver of rights admission form. Have you had an opportunity to do that?
Well, it's being handed to him right now. Let's take a quick moment and review that, sir. Sorry. No, sir, I don't want to rush you through that. So if you have questions, I want you to stop and ask. But if you're okay with it, we can keep going.
Yeah.
All right. All right, thank you. All right. The admission form has been reviewed and signed with counsel.
All right, sir, you understand all the rights on there you're waiving when you enter your admission, including your right to have a hearing in this case?
Yeah.
you understand at a hearing you'd have the right to testify and offer a defense on your own behalf as well?
Yes.
Do you suffer from any mental illnesses?
No.
Are you currently under the influence of any drugs or alcohol?
No.
And you understand if you're not a citizen of the United States, this admission could be used against you in a deportation or removal proceeding?
Yes.
Are you satisfied with your attorney's advice?
Yes.
Any more questions for her or the court before you tender your admission?
No.
Okay, state will tender the admission.
All right. I reviewed the affidavit. I do find that there is a sufficient factual basis in venue. I have considered the colloquy and find the admission to be freely, knowingly, and voluntarily entered. Therefore, I will accept the admission and impose sentence as follows. With the original offense being battery, probation is hereby revoked. You'll be resentenced to adjudication of guilt, credit for time served. And Ellen, are there any additional costs? And a $50 cost for prosecution. And then that's it. All right, you're done with us, sir. Thank you for getting that restitution paid. Good luck to you, okay? Take care. Thank you, Ms. Hall. Yes. Judge Crown said hi, and I'm sorry I kept you late. All right. Okay, Ms. Fish, you've been on for a while. You've been very patiently waiting. Good morning.
Thank you. Good morning. Attorney Monica Fish for Angela Reinhart, case number 2020 MM1666.
Okay.
We are asking for a continuance. This is our first time up after the arraignment, and we waive speedy trial if necessary. We have been, an offer has been extended, but we're hoping to get a diversion. So there are some things I'm getting together for the state. I've gotten some police reports together, and I'm going to go ahead and make another request with the Lee County Sheriff's Office. And I'd like to see if we could have this continued out past her next court date with her paternity case. Her next court date is January 20th. We could have court then after that.
My next pretrial is January 25th.
Thank you. Perfect.
State, no objection to continuance.
No objection.
January 25th at 10 o'clock.
Thank you, Your Honor. Thank you. Bye.
Oops, sorry, that was me. Paper on the microphone.
Judge Brown,
Yes, ma'am.
I missed the name on that one.
I'm sorry, that was Reinhart, Angela Reinhart, 20 MM1666.
Okay, I was shown a different defense attorney. I think that's part of it.
It's the same firm, I think. Ms. Fish is still with the same firm.
Okay.
All right.
Thank you.
Yes, ma'am. All right. Mr. Casassa, good morning.
Judge, how are you?
Doing well. How are you, sir?
Good. I've got one case, Zachary Batcher. Looks like 20 MM1711.
Yes, sir.
I think it's the first time up, Judge. I'm planning on filing a motion for depositions. I want to continue over the waiver of speedy trial.
State no objection.
No objection.
All right, January 25th at 10 o'clock.
Thank you, Judge. Good day.
Yes, sir. All right, you too. Bye-bye. Mr. Carney? Good morning, sir.
Hey, good morning, Honor. Adam Carney with Rhode Island Law on behalf of Jeffrey Goff, 20 MM1485. We're asking for that January 25th date with a waiver.
State no objection.
Objection.
January 25th at 10 o'clock.
Thank you, Judge. Have a great
Thanks,
weekend.
You too. Mr. Payette. Mr. Payette, are you there?
I just have one case, Your Honor. We're asking for that January 25th date. Simon Hernandez, 20 MM1842.
Okay. State no objection.
Objection.
All right.
Can you get me an offer on that? He has an ICE hold, so he's been in custody since the arrest. He'd really like to not be in there anymore.
Yes. Will do.
Thanks, sir.
All right, take care. All right, bye. All right, Ms. Upson? Ms. Upson, are you there? Oh, there you are. Hello, good morning.
Honor, thank you. I have Gibbler 20mm 9-1,
Yes, ma'am.
and we're ready for trial on that.
All right, Steady, you ready?
Yes.
Judge, I believe I'm number 1 and 2 in that January 5th date with Judge Foster.
Okay.
So, I mean, I'm ready, but I'll let the court know if I think I'll be on a bail.
Well, here's the good news. If you go in front of Judge Foster, we know what I'm going to do.
Right. That's true. I don't have to worry about it. You're right.
We only have one panel.
You're right. There you go.
I'm backup. So I'm going to set this on the 4th for status. We'll see what our numbers are. We'll see what Judge Foster, where things are at. And so this is strictly status.
Okay.
Nobody in the courtroom, strictly on Zoom, no witnesses, no jurors, just where are we and can we have a trial that week, okay?
Okay, thank you, Your Honor.
All right, I'll see you then, January 4th at 9 o'clock. Status, excuse me, for status. See,
Judge, is the plan to do more than one if we have the time to do more than one that week?
If Judge Foster, if he washes out and we have a jury, I'd like to try 2 cases that week.
Okay.
If we can, I mean, let's take advantage of what we can when we can.
Okay.
So we'll see.
Thank you.
Thank you, ma'am. All right. I have attorney Michelle Merson, and I'm sorry if I mispronounced your last name. Ma'am, I need you to unmute, please.
Sorry.
All right. Good morning.
Good morning. I'm representing Annie Morgan,
Okay.
and this is our first time up.
All right. This is 20mm 1977. Yes, ma'am. What would you like to do?
We would like a reset.
All right. That's for continuance with a waiver?
Yes, please.
Judge, we haven't filed on it yet, so I would just ask we roll it to Monday 28th arraignment. Actually, if I could ask for 2 weeks out just because of the holidays. If we could set it on the 4th just for an arraignment, we have not made a filing decision.
All right. Counsel, no objection to a 2-week continuance for the state to make a filing decision?
No, no objection.
Okay. All right. January 4th at 9 o'clock for arraignment.
Thank you so much.
Thank you. I'm sorry. Hold on. Just to confirm, Ellen, you've got a January 4th docket for that, right? Just want to make sure with holidays and everything, we haven't changed that.
Yes, that's what I put it on January 4th.
Okay. All right. Very good. Thank you. All right.
Thank you. Bye.
Mr. Nunez? Mr. Nunez, you there?
Hey, Judge, sorry. Jose Nunez. Correct Summerlot.
Please don't talk to me while you're driving. Can you pull over?
Yeah, Judge, I can. Sorry, I was just waiting for the next available spot.
All right.
What if I turn my camera off and I tell you that I pulled over? I'm just kidding. Give me 1 second.
Sure.
Sorry, I had to go get my son from the doctor's office. That's why I'm
sorry.
all right. Totally stopped.
Thank you, sir. It's just bad form to crash into a phone while talking to the judge.
Understood, Judge. And you'd probably be my careless driving judge.
I probably would be the judge presiding over your case.
Your Honor, I noticed that the state recently disclosed a new witness. Although I haven't noticed recently if there was any uploads regarding a statement. James, do you have anything in writing from the new witness, or are we gonna have to depose him? I'm not sure who it is.
He's the one that made the 911 call.
Okay. So we probably don't need a deposition. We have the recording, James, right? In Discovery. I believe I've listened to it, but I can't remember.
I have it.
Okay. So we'll still judge our request at the last court appearance was to set up a trial. I don't know if the court's availability is any better this cycle, or if the state still thinks we'll need more time, but
I'm back up, Judge, the week of the 4th. So we have a chance of having a trial.
Okay.
And so I can set it, if the state's otherwise ready, I can set it on January 4th for status only at 9 o'clock to be on Zoom. No witnesses, no one is required to be present. It's just to see where are we, will the numbers allow for jurors to come in? Where is Judge Foster at with his trials? Because I'm second in line. Does that work for you, sir?
That works, Judge. And my client does not have to be present at the status.
Correct.
Okay. Very good.
And Mr. Stewart, is the state ready?
That's fine, Judge. We can set it.
All right. January 4th, 9 o'clock for status.
Thank you, Your Honor.
Thanks, sir. Take care.
Thanks.
Call me, Judge.
I did, sir.
I'm sorry, I couldn't hear the name. I heard Mr. and I didn't know who it was, but I'm the only one that seems to still be up there other than Mr. Stewart. And I don't think
You're a mister. You're absolutely a mister.
You are the mister.
Judge, good morning. I have Ross Vincent Lacari, 20 mm 1636 on the docket.
Am I going to see him this afternoon?
Yes, I did have the opportunity to speak with him at 5 o'clock on Friday. He does want to resolve his cases. He has 3 of them. I sent an email to your judicial assistant in preparation for that, but I don't know if she's moved on that yet, but I can give you the case numbers. Maybe the clerk can place them on that docket.
Yeah, Ellen, if you would please put all 3 of these cases for a plea at 2:15 today.
The first one is this one, obviously, Judge, it's on this docket, 20 mm 1636. The next one is 20 mm 694. And the other one is 20 mm 1469. And those are all your cases, Judge.
Very good. All right. All right. I'll see you then this afternoon at 2:15. Did you have anything else on this morning's docket?
I don't, Judge. Do I need to do a notice of plea for all 3 of those?
No.
Very well.
Nope.
Okay.
Take care of it this afternoon.
And Mr. Stewart, are you going to be appearing, or is it going to be another ASA?
I don't think it'll be me, but I will speak to them beforehand.
Could you just let them know that we're doing all 3 of them together?
I will. Yes.
Great. Thank you very much, Judge.
All right.
Thank you, Mr. Stewart.
All right. See you this afternoon.
Have a nice day.
You too. All right. Mr. Wilson. Let's
Anna Medina. Is 20 mm 805.
Okay.
Waiver.
All right. Say no objection to a continuance.
No objection.
All right. January 25th at 10 o'clock. I do have a couple of public defender clients on the 9 o'clock that we did not address. Of Alejandro Fernandez.
I can address them, Your Honor.
Yes, thank you, sir.
There's 2 of them, right?
Yep, 14 mm 2795 for VOP arraignment.
I got him, and he's in the jail, our recent client, so, a denial, Your Honor?
All right. All right. The denial is being entered by counsel. Ellen, what will be the next court date?
I'm sorry, I'm still on. Oh. Okay.
Do you need me to hold on a second?
I'm so sorry. I just finished putting Mr. Clark's cases on your 215.
Oh, I'm so sorry. I'm sorry. I moved too fast.
I'm on Medina.
See, normally you would just throw something at me if I was going too fast.
Well, usually I can keep up, or I can catch up anyway.
All right.
I just missed what was going on with Medina. Was that to the next pretrial?
1 moment.
Yes, 125.
Was that with a waiver, or was it previously?
With a waiver.
I'm sorry, which defendant are we on?
The first one we called was 14 mm 2795 Alejandro Hernandez.
Yes.
The defense is entering a denial, and so I need a. You want to set it for status?
Yes, Your Honor.
for VOP status.
Okay, it's still gonna remain on a DV hearing docket.
Yes.
This is Judge Nicola's case. It's gonna be January the 4th at 9 o'clock.
All right, January the 4th, 9 o'clock for VOP status. And then I've got Gilberto Sotelo Garcia, 20 MM 1988, represented by the Public Defender's Office.
Yes, Your Honor, that'd be clear, not guilty.
All right. Has this been filed on?
Yes.
It has.
All right, not guilty plea has been entered. So we'll need a pretrial, please.
Pre-trial is January the 4th at 10 o'clock.
All right, January the 4th at 10 o'clock for pretrial conference. And then I've got 2 no-shows. Paul Dean Arnold, 20 MM 1986.
Judge, on Mr. Arnold, I believe he's in custody. We filed his case as a felony, so I'm in the process of getting rid of the misdemeanor case. So if you could just roll it to next Monday's docket, it'll fall off by then.
All right, Monday the 28th at 9 o'clock for arraignment. And then Arturo Jose Martinez, 20 MM in custody. All right, Arturo Jose Martinez, 20 MM 1994. I've got a jail arraignment docket that I think I'm doing a jail arraignment docket this week.
Tomorrow or Wednesday?
Let me see. I'm doing a jail arraignment docket at 2:15 on the 23rd, Mr. Stewart. Or I could address this case this afternoon.
I would ask to address it this afternoon, and we can do the arraignment today.
All right. Can we add this to the 2:15, please?
Of course.
And was this filed on?
It was.
Yes.
All right. So let's put this on the 2:15 today, please. And I think that's it. Did I miss anything, Ellen?
No.
All right. Thank you, everybody. Mr. Stewart, I'm glad you avoided asking anybody about their stage names today.
That's right. It was an improvement for me. It's a long road back from that kind of mistake.
Even on Zoom, you turned bright crimson red. That was something.
Oh, wow. What a moment. What a moment.
That was something.